Hello again. My name is Daryl Miller. I'm one of the chief advocates here at Parole Advocates. Our mailing address is 1000 Peachtree Industrial Boulevard, Suite 6-248 or 248, Swanee, Georgia. Zip code is 30024. I'm going to go over a summary of the steps or the process of the parole intake process. So when a person comes into the Georgia Department of Correctional System, they usually go to one of the intake prisons. When they come to the intake prisons, usually there will be a parole board member who will interview them, not the 5 board members that sit on the panel, but one of the employees of the parole board will do an interview of the inmate and assess the inmate's mental position at that time as to how they perceive their crime and their incarceration. Usually the determination is made as to if the person is accepting responsibility or they're still fighting their case. And based on whether they accept responsibility or they're still fighting the case, this is one of the factors that plays into the determination of the opinion of the parole board member at that time. They look over why the inmate is in prison, why the inmate sees himself as being in prison, what caused the inmate to be in prison, and what type of case is the person's case. And based on how they interpret the case, they will also put together a recommendation as to what classes that inmate needs before making parole, and also a recommendation as to when they believe or perceive that the person should make or not make parole. They take a summary of the crime, they look at the investigation reports, any notes, information that comes from the district attorney, the victims, the crime, if there are any victims in the crime, that information is also taken into consideration at that time. They take this assessment and they do this pre-parole investigation package and they send it to the parole board members. All right. After this file is prepared and the parole board members receive this file, it is stated that by the parole board that they vote as to when they believe and think that this person should make parole. From my understanding and my research, that the parole board members usually take the recommendation of the parole examiner or that employee that did the initial intake interview of an inmate at the time in which they came into the prospective diagnostic prison. Right? If that date and time is something that does not reflect what the inmate believes or feels that they should have received, they can appeal it by sending in information that will correct it, but the information has to be definitive information that the parole board would consider in terms of correcting their initial evaluation. This evaluation is presented to, the outcome of the evaluation is presented to the inmates in the form of what's called a grid guideline system. All right. When the inmate receives this grid guidelines anywhere from 1 to 2 years after they come into the prison system, sometimes some inmates don't get them at all. Whether it's an error or not, it varies. I usually try to, if I'm working on an inmate's case, to try to inquire as to why the inmate had not received a grid guideline and try to enter information into the file system that will allow the inmate to look more favorable and look like someone who is ready to re-enter society as a law-abiding citizen. That is basically the summary of how the initial parole board process occurs when the inmate first comes in the Georgia Department of Corrections system. The sentence, the crime is considered. Sometimes if the sentence was one of a greater offense and the inmate pled guilty to the lesser offense, some parole examiners have made mistakes in grading the inmate based on their misunderstanding as to the crime that the person was in prison for. It's not uncommon that a person who had initially been prosecuted for armed robbery but pled guilty to robbery, a lesser offense, receives a sentence of 10 years that the parole board wants them to do the whole 10 years because under the laws that relate to armed robbery, one must serve at least minimally 10 years on armed robbery in order to be eligible for parole. Well, that's what's stated on the affidavit or the indictment, that the person is in prison for armed robbery, but the sentence sheet may say state robbery. Well, that person under robbery is actually eligible for parole, but these are one of the mistakes that are made with the parole board. Very common that inmates are graded on the greater crime that they were prosecuted under, but sentenced under lesser charge, and the parole board has applied the greater to them, which is wrong, and there are things that can be done to correct that. We can be reached in contact at our address, or you can contact us at our email at theparoleadvocate@gmail.com. Again, that's the word the parole advocates, plural, gmail.com. Thank you again for watching this video. I hope it's assistance to you. Or you can call us at 404-855-4569. Thank you in advance.